Heavenly Father, we come before you humbly once again, thanking you for this day, asking you to bless this meeting and everyone here. Let us do everything decent and in order to your will. Amen.
Amen. And please join us in the Pledge of Allegiance.
Behind you.
Pledge allegiance to the flag of the
United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please, Mr. Ward.
Mr. Tripp. Present. Mr. Washington.
Present.
Mr. Laches. Present. Mr. Stauffenberg. Present. Mr. Witten.
Present.
Mrs. Bernard. Mr. Marcotte.
Present.
Mr. James. Present. Mr. McLaren. Mr. Vickery.
Present.
Mrs. Barber. Mrs. Schmidt.
Present.
Mr. Nicholas.
Present.
Mr. Olthoff.
Present.
Mr. Lear.
Present.
Mr. Scholl.
Present.
Mr. Hess.
Present.
Mrs. Campbell.
Present.
Mr. Klecki. Mrs. McBride.
Present.
Mr. Yates. Mr. Inns.
Present.
Mr. Whitus.
Present.
Mr. Tholen.
Present.
Mrs. Polk. Mr. Arsenault.
Present.
Mr. McConnell.
Present.
Mr. Foster.
Present. We have a quorum. Public commentary, I have 6 or 7 requests, so you'll be limited to about 2 minutes each. No particular order. Mr. Runyon. Sorry. Visitor.
Hello? Okay, thank you. Thank you, Mr. Chairman. Congratulations to you and Mr. Lair for your new positions. Hope that you will conscientiously govern in for the benefit of the general welfare of the citizens of Kankakee County. I'd like to address a couple of issues in response to the article in the Journal that you gave to the Journal. First of all, I'd have to respectfully disagree with your assessment that the county needs a landfill. Very few counties in the state of Illinois have a landfill. Secondly, there are 18 years of landfill capacity available for northern Illinois. So as you can see, there's no crisis for landfill capacity. So I would beg to differ with you on that and hope that you'll reconsider. Furthermore, if you want to process garbage, by far the most legitimate way to do it is with the alternatives. Number one, the alternatives provide much more revenue than a landfill. And number two, they provide a great deal more jobs than a landfill. For instance, Pontiac, which has been the second largest landfill in the country, hires less than 20 people. Whereas St. Lucie County, Florida's plasma arc system hires 80 people, and the system going into Lake County, Indiana will hire 100 people. So from a labor point of view, a landfill makes no sense whatsoever. Anyway, that's basically all I have to say about that, except I hope the county will continue to vigilantly pursue its opposition to the Bellini-Barbara landfill. The cost of pursuing that is minuscule by comparison to the cost of the economy of Kankakee County if that gets cited, because all objective scientists and engineers agree that that landfill will leak, it will contaminate our water supply. A contaminated water supply means the county will have no economic future. Thank you.
Thank you. Mrs. Marcotte.
This way.
Thank you, Mr. Chairman. I too am going to refer to the Journal article that was an interview with you. I appreciate your statement that you realize that it is advantageous to have someone local do inspections for the delegation agreement. You state that the IEPA has objected to the county health department doing inspections and you ask a rhetorical question, so what are we to do? My suggestion is that you listen to the constituents of Kankakee County, which consists of people in the western part of the county, south of Kankakee, and the eastern part of the county, specifically the Momence River Conservancy. There are representatives here today. That you listen to all the citizens and not maybe so much emphasis on the other side, and create a separate department, which is not have a department head, political pressure placed on a department head for an inspector to not perform the inspections the way the state regulations say they should be done. So that's my suggestion, is that you do create, that this county board creates a separate department for a IEPA delegated inspector. I don't know how much more time I have, but just wanted to add that when the program in 2004, the grant money from the state was only in the area of $23,000. I believe the latest figure on the table is somewhere around $65,000 that the state has agreed to give the county to perform the local inspections. With this day and age, we have cell phones. You don't have to have a specific secretary for a person that would do these state inspections. So that's my suggestion. Thank you.
Thank you. Mrs. Taylor? Carol Taylor?
I'd like to thank the board for all their cooperation with the group that I represent. It's a power organization. We have done a great deal of research on the landfill in our township. We've got all the information. Nothing has changed. It's not something that we want to have happen, because we want to save the Kankakee River. And if there is a landfill in that area, it's going to contaminate it, and 20 years down the road, our legacy will be, why didn't people do something before it got to this point? I respect this board. They've been very good, and I hope they continue with the appeal to the Supreme Court to stop this landfill. It's in the wrong place. I've lived there all my life. I was there in '57 when everything was flooded. It can happen again. And if it does, and there's a landfill there, forget about your water supply. Not just the wells, the Kankakee River. Thank you.
Thank you. Ron Thompson?
Thank you, Mr. Chairman. A few years back, when they were doing the siting hearings for the landfills, the Kankakee Daily Journal quoted me as being the outspoken critic of the landfills. I still wear that badge proudly, and nothing has changed. But I'd like to encourage this board to continue on with the fight against the Bellini landfill. It's in the wrong spot. It's in an aquifer. And as Keith said, we have 18 years of space for landfills. In that 18 years, technology changes a great deal. Just in the past 7 years that we've been fighting the landfill, it's changed considerably. There were no alternatives to speak of. You buried your garbage, and that was it. But I would encourage this board to look into some of those alternatives for the landfill, and possibly even get rid of the Chicago garbage and just have it for our own benefit, our own county. Thanks.
Thank you. Darrell Bruck?
Good morning. I too am going to refer to the Kankakee Journal interview with Mr. Bosser. I think a key statement you said in that interview is, I wish we I just wish we had an appropriate location. And that's the key. It's the location. The Illinois Department of Natural Resources just last year, 5 years after the second application, issued a mandatory order that approximately a mile long by a 300-foot wide, that's the width of a football field, relief channel would have to be dug out there before any development, be it a dump, a factory, or what have you. And that's really key. And as you know, you won the first Supreme Court case, which affirmed that that site out there does not protect the health and safety of the community. And right after that, Blagojevich was elected, who was arrested this morning. He put Novak in as the Pollution Control Board chairman for a few months, and he rammed the thing through, and Novak donated $25,000 to Blagojevich's campaign, and then a few months later retired at a huge boost to his pension. And we all know about Mr. Fred Barber. The Chicago media has covered the fact that he was implicated in a mob bombing last fall in a federal trial, and he's connected to Blagojevich and to Mayor Daley. So this community don't need to connect itself to these types of individuals at a location that puts our water supply. So I want to thank Chairman for his comments in there and realizing about the facts that all the issues were never addressed by the appellate court, and the fact the site is not appropriate. And I certainly hope the county board maintains the status quo, and together we're going to win this, because as you know, we have a case there too. Thank you.
Thank you. Ron Hansen?
Good morning. I'd like to address the landfill issue also, only I think a lot's been said about it already. My perspective is that there is gold in rubbish anymore, whether it's energy use, recycling, and if the county board would look to the current technology, the providers of it, and contract out the picking up and disposal of our trash, somebody might even pay you for allowing them to do it. And we would solve the issue of whether we should have a landfill or not. We might be able to take it from other areas, although that's a bad deal because of all the truck traffic it generates. I'm on Dixie Highway quite a bit. I see all the trash trucks coming out of Chicago. I just encourage you not to do anything that's going to bring more truck traffic down Dixie Highway 57, 45, 50, or any of those highways. My next issue is, in general, taxes. As you all know, the economy is less than spectacular right now, and one thing government can do, the best thing you can do, is leave more money in our pockets. Now, I, like everybody else, received my tax assessment. Since I had appealed and gotten it down last year, I find that it went up even more this year than it was up the year before. According to our Bourbonnais assessor, it's not his fault. Somebody from the county has decided that our assessments should all go up. So if that's true, I urge the county board to look into that. Perhaps you could give a blanket amnesty to everybody on their increases for a year. Again, leaving more money in the pockets of citizens is far better than putting it in the pocket of government, which is the obviously the most inefficient place we can put anything. Enforce the laws, keep us safe, and let us take care of ourselves and our own money. Thank you.
Thank you. And finally, Elizabeth Dunbar.
Morning. Thank you, Mr. Chairman. I'm here in support of passing the Historic Preservation Ordinance. This has been approved by the Historic Preservation Commission, of which I'm the chairperson. Mr. Boyd did attend our December 1st Historic Preservation Commission meeting. He reviewed some minor changes that he had made to the ordinance. We passed the ordinance. We're very pleased with the changes and the presentation of it at the meeting today. Passing the ordinance gives us status with the Illinois Historic Preservation Association. It provides us the opportunity to create landmark status and designate buildings in the county that we feel are threatened or deserve recognition as historic properties. It also gives us the opportunity to apply for grants from the state to assist us in our work, so thank you.
Thank you. That's all the requests I have for public comment. We'll move on. I have no communications. I have no vacancy appointments at this point. Certificates of recognition, we have several today. Is Mr. Boyd, Teresa Willis here?
Either Reed or his case.
Okay. Kevin Duvall, let's have you come up a minute. Kevin, we're going to pretend they didn't have the correct frame on hand for your certificate, so it's going to look a lot like that one over there. Kevin's been with the county for 10 years in our IT department, and the IT people are an important component of our government, keep things working smoothly. They work in the background and are essential components of how we function in this day and age. Things have changed greatly in 10 years, I'm sure. Yep. So thank you very much. Second, we have a 20-year plaque here for a Harold Einfeld. Rick, is he here? Rick's not here either. He out in the hall? Okay. Well, Rick Einfeld, 20 years. Minutes of the last meeting have been distributed, and for your review, we are approving the December 1st concluding meeting of the prior board as well as the reorganization meeting of the current board. Are there any additions or corrections to either one of those sets of minutes? Hearing none, I think one motion would be in order to approve both sets of minutes. Mr. James with a motion, Mr. Tripp with a second. Discussion? All in favor say aye. Aye. Opposed say no. Motion carries. Claims Committee report.
November 26, 2008. Mr. Chairman and members of the County Board, your Committee on Claims would beg me to report that they've examined the following claims presented directly to payment. The court is hereby authorized and directed to issue orders for the several claimants payable out of the funds as follows. For the General Fund, $1,876,396.48. All other funds, $1,738,457.10. Total of the month of November 2008 of $3,614,853.58. For the Highway Fund, $31,710.48. All other funds, $905,125.59. For a total of the month of November of $936,836.07. All of which is respectfully submitted. Mr. Vickery, Mr. Goltoff, Mr. Scholl, Mr. Lear, Mr. Stopberg, Mr. Bossert, Mr. Washington, Mr. Legess, Mr. Cruz, and Mrs. Wilson.
Okay, is there a motion to approve the Claims Committee report? Mr. Vickery, a second from Mr. Altoff. We need a roll call vote, please.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Legess?
Aye.
Mr. Stopberg?
Aye.
Mr. Witten?
Aye.
Mr. Menard?
Aye.
Mr. Marcotte?
Aye.
Mr. James? Aye. Mr. Vickery?
Yes.
Mrs. Schmidt?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Plecky? Aye. Mrs. McBride?
Aye.
Mr. Inns?
Aye.
Mr. Whitus?
Aye.
Mr. Tholen?
Aye.
Mrs. Polk? Mr. Arsenault?
Aye.
Mr. McConnell? Mr. Bonser? Aye.
Motion carried. Department reports.
The County Collector's Monthly Report. We've examined the October 2008 monthly report of the County Treasurer and ex officio County Collectors, and to the best of our knowledge, finds to be true and correct. County Treasurer's Monthly Report. We've examined the October 2008 monthly report of the County Treasurer and ex officio County Collector, and to the best of our knowledge, finds to be true and correct. For the October 2008 Coroner's report,
Leo.
total
Bob Scholl.
There were 268 coroner cases, 764 medicals, 89 autopsies, 93 toxicologies. Income summary for 2008 of $2,083. The report of the circuit court clerk of fees from October of $293,070.29. The recorder of deeds report for October 2008 of $97,340.25. County clerk report for the month of October 2008 of fees of $11,077.74. The Animal Control Department for October 2008 total of the monthly fees of $6,382.75 and 160 animals handled. The report for the permit fees for November from the Building Department of November 2008. Total permits and evaluation, there were 58 with evaluation of $2,570,991 and fees of $1,500. And we are in receipt of the monthly resolution list.
A motion to approve the department reports. Mr. Marcotte, second for Mr. N. Discussion? Questions? Voice vote. All in favor say aye. Aye. Opposed say no. Motion carries. Committee presentations and resolutions. Consent agenda. Why don't we read through the titles of the various resolutions?
The resolutions of the county board for the consent agenda. The resolution appropriating funds for the payment of the county engineer's salary and authorizing the transfer of service transportation program funds. The county maintenance resolution. The appointment of Elizabeth Dunbar to the Kankakee County Regional Planning Commission. Reappointment of Gerald Hoekstra as Commissioner to the Little Beaver Special Drainage District. The reappointment of Martin Graff as Commissioner to the Spring Creek Drainage District. The reappointment of Owen Bunty as Commissioner to the Gilbert Special Drainage District. The reappointment of Michael Lambert as Commissioner to the Exxon Creek Drainage District. The authorization to hire the accounting firm of Smith, Kaling, Dykstra Home as to audit past annual statements. The Tribe Village Development Regulations, Versatech Grove Subdivision Final Plat, the amendment to Chapter 111 Subdivision of the Kankakee County Code, and the extension of the board review.
Are there any questions on any items on the consent agenda? Mr. Enns?
Yeah, I'd like to have H and
And just a minute. Mr. Enns, there you go.
I'd like to have H and K pulled. I'd like to have a little discussion on one of them, and I have a question on the other.
Is there a quick question we can answer, or?
Probably on K. On page 10 of that article, it says that we are creating a position of a plat officer, and I just wonder what his pay is going to be, who it's going to be, are we hiring a new person? I'd like to have a little more information on that.
All right, why don't we pull that one off? We'll have a little bit of discussion on that one point. K is pulled off the consent agenda. Is there anybody? And H. Mrs. Bernard?
I would like I and J pulled off.
Very well. Any other questions? Okay, so we're voting on A through G and L. Roll call vote, please. Need a motion to approve the consent agenda. Yes, Mr. Wade. A second from Mr. Collect. Any other discussion? Roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Legess?
Aye.
Mr. Stauffenberg?
Aye.
Mr. Witten?
Aye.
Mrs. Bernard?
Aye.
Mr. Markcott? Mr. James? Aye. Mr. Vickery?
Aye.
Mrs. Schmidt?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear? Mr. Scholl. Mr. Hess.
Aye.
Mrs. Campbell.
Aye.
Mrs. McBride. Mr. Innes. Mr. Whitus. Mr. Plecky.
Aye.
Mr. Tolan.
Aye.
Mrs. Pope. Mr. Arsenault.
Aye.
Mr. Connell. Mr. Costa.
Aye. Carries. Okay, item H, authorization to hire a accounting firm of Smith County, Dexter, and Elm. This is the engagement letter, basically. It's a routine matter each year for finance to direct the accounting firm to begin business. Mr. Enns, did you have a question?
Yes, I do. Was this, I do have a question, Mr. Chairman. Was this item put out for bid?
The last bid was 3 or 4 years ago. This firm was successful bidder at that point. This is not a routinely annual bid process.
Okay, it's my understanding that it's standard practice to change an auditing firm approximately every 5 years. And I would like to suggest that we would put this out for bid.
Other comments? Mr. Vickery?
Motion to pass.
I have my hand up.
Well, we can have discussion.
Bernard?
Don't we need a motion?
No. We need a motion. There's a motion, we need a second, and then Mr. Bernard can speak.
Okay. I have a motion on the question. Mr. Scholl, is there a second? Mr. Olthoff, I have a motion and a second. Now, questions?
Yes.
Mrs. Bernard?
Thank you, Mr. Chairman. What is the deadline if we were to go out, because that might not be a bad idea. I mean, the auditors have been doing a good job, but it might not be a bad idea to change, make some changes once in a while just to keep circulating things. So what is the deadline for getting this done?
Process starts now, and, the audit has to be completed by, May or June is the deadline. So we go out for bids now, we're setting the whole process back 2 or 3 months. Would suggest if you want to seek bids, that would be a valid discussion next summer as we're preparing for the next cycle. I feel it's too late for this year.
Yeah, I would suggest we look at doing that next year, simply because it's good just to change hands once in a while, and then we can always revert back in a few years.
Any other comments? Let's call the vote. Roll call vote, please.
What's an aye vote?
The aye vote is approving the authorization with Bacon Smith Kelly. Smith Kelly Dexter.
Mr. Washington?
Aye.
Mr. Legess? Aye. Mr. Stauffenberg?
Aye.
Mr. Witt?
Aye.
Mrs. Bernard?
Aye.
Mr. Marcotte?
Aye.
Mr. James? Aye. Mr. Vickery?
Aye.
Mrs. Schmidt? Mr. Nicholas?
Aye.
Mr. Olthoff? Mr. Weir?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Colecki?
Aye.
Mrs. McBride?
Aye.
Mr. Innes?
Aye.
Mr. Whitus?
Aye.
Mr. Tholen?
Aye.
Mrs. Pope?
Aye.
Mr. Arsenault?
Aye.
Mr. Connell? Mr. Bossert?
Aye. Carries. Item I, Tri-Village Development Regulations. Mr. Olthoff? Mr. Stoll?
Yeah, I have a...
Ms. Dietz.
Thank you, Mr. Chairman. I just have a question on the previous action. Do we, or can we at this point, the suggestion was made to take it out for bids next year, do we need, or should we put that in a motion form at this time, or is it necessary?
Guess it would be my suggestion we take it up with Finance Committee at the appropriate time. Item I, Tri-Village Development Regulations. Do I have a motion to approve this regulation? Mr. Vickery, second from Mr. Marcotte. Discussion. Question. Mrs. Bernard.
Thank you, Mr. Chairman. I asked to have you hold off the consent agenda because I am concerned about the number of variances that the subdivision is getting, and I just didn't want to throw out the baby with the bathwater by having it on the consent agenda, so.
Mrs. Bernard, I think you might be confused. The Tri-Village
I'm sorry, I was
Development
looking at the words
Regulation.
text, my bad, I'm sorry. No,
this-
oh, the Tri-Village, yes, the question I did have, I'm sorry.
Okay.
The question I had with the Tri-Village was, how are those regulations, are they conforming to county code, or are we conforming to the village's codes? I mean, what is the ultimate result that we have here with those?
And the ultimate result is that we are trying to put together a hybrid of regulations that are compatible with the type of development we want to see in this area. Most of them, if not all of them, are stricter than what our county-based regulations are. But it goes to an idea that we put together with the villages in the county as to how we would want to see an area in our county that's seen probably, or has seen the most intense development pressures, how we want to see it develop, and also maintain and preserve the area for the new interchange.
Thank you.
Any other questions?
Make a motion to accept the tri-village.
Motion's on the table and a second, so all in favor say aye.
Aye.
Opposed say no. Motion carries. Thank you. J, Diversitech Grove subdivision final plat. Do I have a motion to approve? Mr. Witt, second from Mr. Stoffer. Discussion, questions? Mrs. Bernard.
I'm sorry about the timing. I just have concerns because we're giving a lot of variances, and I just think we need to try to be consistent with our regulations and on this. And I'm just concerned because it's, you know, this subdivision is going to have an impact on the adjacent arterial road. So I really don't think we should be getting developers passes, and I really think we should not be passing these variances.
Other comments?
Roll call, please.
I guess my comment is this, we're long past granting variances. The preliminary plat was approved some time ago, and we're just down to the final stage at this point. Any other comments or questions? Voice vote, all in favor, say
No,
aye.
it's for roll call.
I'm sorry, Mrs. Bernard did ask for a roll call. Roll call vote.
Mr. Tripp? Aye. Mr. Washington?
Aye.
Mr. Burgess? Aye. Mr. Stoffer?
Aye.
Mr. Witt?
Aye.
Mrs. Bernard?
Nay.
Mr. Marcotte?
Aye.
Mr. James? Aye. Mr. Vickery?
Aye.
Mrs. Schmidt?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Colecki? Aye. Mr. Bride? Mr. Inns? Aye. Mr. Whitus? Aye. Mr. Tholen? Aye. Mr. Pope? Mr. Arsenault?
Aye.
Mr. McConnell? Mr. Bossert?
Motion carries. Item K, amendment to the Chapter 117 subdivision ordinance of the Kankakee County Code. Do I have a motion to approve? Mr. Washington, second from Mr. Colecki. Discussion, questions? Mr. Inn.
Yeah, I have the same questions I brought up before. I'm wondering, this position that we're creating, that it says we're creating, how we're gonna fill it, who has approval, what salary is this going to be, and questions of that.
I think Mr.
Enns is referring to the position of plat officer. Plat officer position is already instilled in our job descriptions. We've had the position of plat officer as a designee for at least the last 40 years. It is not a new position. It's just a designation who oversees the process for development.
So we're basically codifying what is in practice now.
That position has always been recognized in the subdivision regulations.
And may I ask you, is there a separate salary for this, or this is just part of someone's
It's rolled into the job descriptions.
Okay, it just was confusing because section 11737 says this position is created, and I just wanted to clarify that.
Any other questions, comments?
Mr. Chairman.
Mr. Boyd?
Mike, I don't have a copy of the ordinance here. Is this the ordinance that includes the special assessment districts?
Those have been taken out, as well as any reference to homeowners associations.
Any other questions? Valid question, Mr. Inn. All in favor, say aye.
Aye.
Opposed, say no. No. Motion carries. That's all for the items that were under the consent agenda. Item 2, planning, zoning, agriculture. A, ZBA case 08-12, rezoning from an A1 ag district to a rural estate district. Mr. Clark needs to read the resolution into the record.
Resolution of the County Board of Kankakee County, Illinois, ZBA case 812, rezoning from A1 agriculture district to RE rural estate district. There is an application pursuant to the terms of the Kankakee County zoning ordinance has been filed by Dennis and Annie Bringleson, property owners and applicants in the office of the county clerk of Kankakee County for a rezoning from A1 agricultural district to RE rural estate district on a parcel legally described herein in Exhibit A, a copy of which is attached herein and made a part hereof. And whereas the zoning board of appeals has caused the public hearing after due notice to be held on said application on October 27, 2008, from the testimony and evidence presented, made findings as described in Exhibit B, a copy of which is attached herein, and made a part hereof, and made recommendation that said request be approved. Whereas the Planning, Zoning, and Agriculture Committee at its regularly scheduled and duly noticed meeting of November 25, 2008, having reviewed, discussed, and considered the matter, concurred with the approval of the request and adopted said findings and recommendation of the Zoning Board of Appeals, Exhibit B. Whereas all matters required by law of the state of Illinois and zoning ordinance of Kankakee County to midnight have been done. Whereas this county board at this regularly scheduled meeting of December 9, 2008, has now reviewed, discussed, and considered the said findings of the zoning board of appeals and said committee minutes of the PCA committee, and now finds that the conclusions expressed therein are both reasonable and rationally supported by the evidence that has been presented, and the rezoning will not be detrimental to public health, safety, and economic and general welfare. Now therefore be it resolved by the Kankakee County Board, State of Illinois, as follows. Number 1, findings of the zoning board of appeals, Exhibit B herein are hereby approved, confirmed, ratified, and adopted, and the conclusions of the Planning, Zoning, and Agriculture Committee based upon those findings are rational in the public interest. And number 2, findings, conclusions, and recommendations expressed in the minutes of the Planning, Zoning, and Agriculture Committee meeting November 25, 2008 are also supported by the record and the public interest, and also approved, confirmed, ratified, and adopted. And number 3, the rezoning from A1 Agriculture District to RE Rural Estate District be approved on parcel legally described in Exhibit A, a copy of which is attached herein and made a part hereof. The committee recommends the adoption of this resolution here was submitted. Voting aye, Mr. Stauffenberg. Voting nay, Ms. Hertzberger. Mr. Hess voting aye. Mr. James, nay. Also voting aye, Ms. McBride, Mr. Marcotte, Mr. Schultz, Mr. Tholen, Mr. Tripp, Mr. Washington, Mr. Whitten. Voting nay, Mr. Turner.
I have a motion to approve. Mr. Whitten, a second for Mr. Washington. Explanation, Mr. Skimmerman.
Good morning. As the resolution stated, this is a request by Dennis and Annie Bringleson to rezone a piece of property outlined in red on this map up here from A1 agricultural zoning to RE rural estate zoning for the purpose of building a single-family home on the property. The property is located in Rockville Township on 2250 West Road, just north of 8270 North Road, which is also Bluegill Road. The property is 3.73 acres in size, and there is a minor subdivision plat, which will be the next agenda item that goes along with this. A letter of objection was received at the zoning hearings from the Rockville Township Planning Commission. Their objection was based on inconsistency with their comprehensive plan, which recommends that all new residential development be on 5 acres. Zoning Board of Appeals voted 5-2 to recommend approval, and PZA also voted to recommend approval.
Questions, comments? Mrs. Hertzberger?
Thank you, Mr. Chairman. Albert, can you give a little bit of history on this parcel for the board as far as how it got subdivided in the beginning, so they understand why some of us voted no?
This area here is an 8-acre parcel, which was divided out of the farm parcel down here, which was a couple of hundred acres. Then this parcel was further divided into one 5-acre parcel and then the 3.73 acre parcel. And that happened about a year, 2 years ago, that division.
But originally the division was not legal, or?
The division does not follow the Illinois Plat Act, so therefore that's why the minor subdivision is coming up next would be required as well.
And it doesn't fit our subdivision or our ordinances for subdividing land, correct?
That's why it needs the minor subdivision.
Questions? Comments? Okay, again, this will require a roll call vote. This will require a 3/4 vote of the entire board membership because we are acting above the objection of the Township Planning Commission. Okay, so 21 votes. Roll call vote, please.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Legess? Aye. Mr. Stauffenberg?
Aye.
Mr. Whitten?
Aye.
Ms. Bernard?
Aye.
Mr. Marcotte?
Aye.
Mr. James? Nay. Mr. Vickery?
Aye.
Mrs. Schmidt?
Nay.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Schultz?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Colecki?
Aye.
Mr. Pride?
Aye.
Mr. Inns?
Aye.
Mr. Whitus?
Aye.
Mr. Sullivan? Aye. Mr. Pope? Mr. Arsenault?
Aye.
Mr. Connell? Aye. Mr. Fawcett?
Aye. Motion carries 23-2. Kincaid Grove subdivision. We have a motion for approval. Mr. Scholl, a second for Mr. Olthoff. And Albert, you want to explain that again? This is a
Sure.
companion item to what we just passed.
This is the second part of the zoning case. Because of the division of less than 5 acres, a minor subdivision plat was required. It's called Kincaid Grove subdivision. It's one lot. They went out for 45-day review. We had comments on it. County Highway asked that the right-of-way be dedication be increased from 35 feet to 40 feet. That was done. They also asked that an easement of access for the south branch of Rock Creek also be added, so a 90-foot easement of access was put in at the creek line. It's located in the same lot that the zoning case, was. There is floodplain on the lot. This is the floodplain line right here. Everything from here up is in floodplain. The buildable area is the triangle at the bottom.
I skipped over the reading of the resolution. Took away Mr. Clark's glory.
Resolution of the County Board of Kankakee County, Illinois, whereas an application for preliminary final plat was filed with the Kankakee County Planning Department on September 23, 2008, for Kincaid Grove subdivision, a minor subdivision located in Rockville Township in Kankakee County, Illinois, with the subdivision developer Dennis and Annie Bringleson and the engineer Tyson Incorporated. Whereas the preliminary final plat was filed on September 23, 2008 for review and sent to the following agencies for comment, November 10, 2008. Whereas an application for approval of the final plat of the Kincaid Road subdivision, minor subdivision, is required under the terms of the Kankakee County subdivision rules and regulations, has been filed in the office of the Planning Department of Kankakee County, and by said office reviewed and delivered to the Planning, Zoning, and Agriculture Committee of said county. And whereas said final plat, a copy of which is attached here to Exhibit A, incorporated by reference and made a part hereof, has been reviewed by the Planning, Zoning, and Agriculture Committee, found to conform to the existing rules and regulations, and whereas the Planning, Zoning, and Agriculture Committee has regularly scheduled a duly noticed meeting on November 25th, 2008, to review, discuss, and consider the matter, recommended that said final plat exhibit herein, Exhibit A herein be approved with the conditions of the County Highway Department be met. Whereas all matters required by law of the state of Illinois and subdivision rules and regulations of Kankakee County have been done. Now therefore be resolved by the Kankakee County Board, State of Illinois as follows. Number 1, Section 117-124 F2 requires the Collector Street shall have a minimum right-of-way width of 80 feet. Number 2, Section 117-123 requires that there be appropriate dedication or easement provisions where subdivision is traversed by a water course, drainage way, channel, or stream. Now therefore be resolved that the Kankakee County Board at its regularly scheduled meeting of December 9, 2008, after review, consideration, discussion, accepts, and adopts the minutes and recommendations to the Planning, Zoning, and Agriculture Committee, November 5, 2008, hereby approves the final plat of Kincaid Road subdivision with the conditions of the Kankakee County Highway Department being met, Exhibit A herein for recording. The committee recommends the adoption resolution herewith submitted by Mr. Stauffenberg. Voting aye. Mr. Richburger, nay. Mr. Hess, aye. Mrs. Bride, aye. Mr. Marcotte, aye. Mr. Scholl, aye. Mr. Bell, aye. Mr. Washington, aye. Mr. Whitman, aye. Mr. McLaren, aye.
Now, discussion. Mr. Stauffenberg?
Yeah, Mr. Chairman, thank you. I supported this because there's really no other use for this land. As you can tell with the floodplain on it, we might as well get some tax dollars out of it. And I thought as a county, we were trying to defer from 5-acre land uses because 4 of it usually turned into be weeds and things else. So my reason for supporting it, I respectfully honor the Rockville Township's request in their ordinance of 5 acres, but I think they might want to look at that because we're trying to get away from 5-acre lots in the county, and they tried to do that in the past, so my reasoning.
Other discussion? Let's do a roll call vote again.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Legess? Aye. Mr. Stauffenberg?
Aye.
Mr. Witt?
Aye.
Mrs. Bernard?
Aye.
Mr. Marcotte?
Aye.
Mr. James? Aye. Mr. Vickery?
Aye.
Ms. Schmidt?
Nay.
Mr. Pickles?
Aye.
Roltoff? Mr. Lear? Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Pilecki? Aye. Mrs. McBride?
Aye.
Mr. Innes?
Aye.
Mr. Vitus?
Aye.
Mr. Dolan?
Aye.
Mr. Pope? Mr. Arsenault?
Aye.
Connell? Aye. Bossert?
Aye. Motion carries. Item C, Historic Preservation Ordinance. Do I have a motion to approve? Mr. Scholl, Mr. Vickery with a second. Perhaps first, let's have a motion to waive the reading of the resolution. Mr. Dolan with the motion. Mr. Whitten with the second. All in favor say aye. Aye. Opposed say no. Motion carries. Now, there's no question. Discussion? Explanation?
Mr. Chairman, briefly, this is a comprehensive ordinance for the operation of the Kankakee County Historical Preservation Commission. It was in part drafted by the commission and is a merger of several other ordinances from other jurisdictions. Our office took a look at it. There were some minor changes we had to make. Those were made. I believe Ms. Dunbar and her commission are satisfied with this ordinance. The idea was to get an ordinance that we wouldn't have to keep going back to for amendments over and over as things came up. This is a comprehensive ordinance and it should do the job for the Historic Preservation Commission. I would recommend passage because once this ordinance is in place, the Historic Preservation Commission can begin to act on getting grants and other recognitions. So that's our office's position. We recommend passage.
Mr. Innes.
Yes, Mr. Chairman, I have no objection to this ordinance, but I do object that just having this thrown on our desk this morning. I think this should have been brought to our attention so we can thoroughly read it. In the future, hopefully, we can have that done.
That's a valid point, Mr. Chair. That's a valid point, Mr. Renz. I don't like throwing things on your desk at the last minute either. Unfortunately, due to the time constraints as to when the commission met and when I was able to get this amended, it just dictated this. So I apologize to the members of the board for that. It was not my intention to try to slip anything by you. Certainly, I try to avoid that at all costs. I'm getting things to you late.
Mrs. Bernard?
Thank you, Mr. Chairman. Going along with that, I would recommend that these ordinances, as much as possible, try to get posted at least online a few days. And, if we can't have them on our desk, at least send an email to all the county board members, let them know, hey, it's online if we don't have the print version ready yet.
Thank you. Comments to the ordinance? Mr. James, number 7. Okay.
Thank you. My question is, if one of us were to read this over and have a change on it, could this be changed after we voted through? Could we make an amendment at a later meeting to make a change without putting in jeopardy what we're trying to accomplish.
Absolutely, at any time, the members of this board can move to have an ordinance amended regardless of when that ordinance was passed.
Thank you.
I have a motion and a second. All in favor, say aye.
Aye.
Opposed, say no. Thank you. Carries. Thank you. Item 3, Finance Committee, Annual Tax and Levy. We need a resolution into the record.
Resolution of the County Board of Kankakee County, Illinois, annual tax levy 2008-2009. Whereas the county board may cause to be levied and collected annually taxes for county purposes upon all taxable real property and railroad property is assessed or equalized by the Illinois Department of Revenue for each object and purpose. And whereas the 2008-2009 annual budget appropriation resolution adopted and passed at the November 12, 2008 county board meeting, resolution number 2008-11-12-166 specified statements of budgeted revenues and expenditures for the fiscal year commencing on the first day of December 2008 and ending the 30th day of November 2009, whereas the County Finance Committee was assigned the responsibility of preparing the annual tax levy resolution for the 2008-2009 fiscal year and finds and determines that for county purposes it will be necessary to levy taxes in the aggregate total amount of $16,058,090 upon the real property and railroad property for each object and purpose. And whereas the county board concurs with the finding and determination of the County Finance Committee as to the necessity of said tax levy, now therefore be it resolved by the County Board of Kankakee County, Illinois, as follows. Section 1. That the aggregate total amount of $16,058,090 upon the real property and railroad property assessed or equalized by the Illinois Department of Revenue for each object and purpose. A, the sum of $16,058,090 are hereby levied upon all taxable property and railroad property. The county is assessed or equalized by the Department of Revenue in order to meet and defray all necessary expenses and liabilities the county is required by statute or voted by the people in accordance with the law for the following tax cap purposes as set forth further in the county budget document as summarized. For corporate, $4,284,688, IMRF, $2,274,143, county highway, $1,811,100, $8,811,112, joint bridge, $885,395, highway tax, motor fuel, $885,395, county health, $461,858, liability insurance, $2,505,898, Social Security, $1,768,778, Extension Education, $366,054, Veterans Assistance Commission, $211,768, lease for the Public Building Commission, $603,001. The aggregate nothing for general obligation bond for county health lease. B, the aggregate sum of $603,001 hereby levied upon all taxable real and railroad property in the county is assessed or equalized by the Department of Revenue in order to meet and defray all necessary expenses and liabilities of the county as prepared by statute in accordance with the law for the non-tax cap purposes. Will County Public Building Commission needs $603,001. Section 2, the county clerk is hereby directed to certify the amount of to be raised by taxation and cause the aforesaid amounts extended upon and against taxable real property and railroad property within the county of Kankakee as required by law. Section 3 of any section subdivision pursuant to this resolution shall for any reason be held invalid or be unconstitutional. Such finding shall not affect the validity of the remaining portion of the resolution. In Section 4, this resolution shall be in full force and effect upon its adoption as provided by law. The committee recommends the adoption of this resolution that was submitted by Mr. Vickery, Mr. Oldhoff, Mrs. Campbell, Mr. Bossert, Mr. Legust, Mr. Lear, Mr. Scholl, Mr. Stopford, Mr. Washington, Ms. Wilson, Mr. Cruz.
We have a motion for approval of the levy. Mr. Vickery with a motion, Mr. Washington with a second. Discussion? Questions? Mrs. Bernard?
Thank you, Mr. Chairman. What's the comparison of this year's levy to last year's?
Last year's extension in aggregate, including the public building lease, was $15,347,000. This year's levy request, $16,058,000, 4.6% adjustment from prior year. within that, various line items are some are higher, some are lower. Mr. Stauffenberg?
My question is, if somebody appeals their taxes, does that change these numbers? And wins if they win their appeal?
No.
Doesn't change.
The individual's assessment does not affect what in aggregate the county collects unless it changes the tax base and the tax cap calculation. That's it. Attempt to confuse you, but the taxpayers as a whole pay this amount of money, and the assessments just divvy up who pays what.
You know, our assessed valuations just came out, and the equalizer in my township went up 5%. I guess I'm kind of wondering who sets that percentage and how it could be done without a county board. I think we're going to have 1,000 appeals just out of Manteno Township. Yeah, I've probably had 50 phone calls, and I don't know who. I'm assuming our assessor raised the equalizer, but I don't know who gives them approval or how that process comes about, but I'd like to know for further years to come, because I've never had so many phone calls.
It's probably a discussion outside the scope of this resolution, but it's a valid discussion in terms of the duties and responsibilities of the assessment office. It's not the county board setting any multipliers. It tends to be a function of the chief assessment officer within the county, and if those numbers are inadequate, then the state will step in and make a county-wide multiplier. So there's checks and balances all along the line. Any other questions? Roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. Letchett?
Aye.
Mr. Stauffenberg?
Aye.
Mr. Whitten?
Aye.
Mrs. Bernard?
Aye.
Martha?
Aye.
James? Mr. Vickery?
Aye.
Mrs. Schmidt?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mrs. Campbell?
Aye.
Mr. Flecky?
Aye.
Mr. McBride?
Aye.
Jim?
Aye.
Mr. Whitus?
Aye.
Mr. Pope? Mr. Arscott?
Aye.
Mr. Connell? Bossert?
Aye. Carried. Mrs. Campbell.
Is there a way we can get an answer to what Mr. Stauffenberg brought up, and I know all of us, because we got our assessment too, and we didn't understand it. Is there a way we can find out who determines this multiplier? I mean, somebody has to give him direction. Can we find out from how this is done?
Hate to put Mr. Beatty on the spot. Maybe this would be more appropriate at the finance committee, the next finance committee. Could I refer that to the finance committee chairman and get that on the agenda for the next meeting? Those who are interested in that discussion would be welcome.
Address our state's attorney on this before we take it there, because there are some people here that are curious that are entitled to some type of an answer.
I guess in this manner, I concur with the chairman. These are matters that are decided by your township assessor, which those assessments are overseen by the supervisor of assessments, whose job it is to take the assessed values over the past 3 years, along with the multipliers that are recommended by the state of Illinois, in an effort, I hope, to avoid a countywide multiplier, so that each property is appropriately assessed. There are formulas that are involved, and to be quite honest with you, today is neither the time nor the place to have that detailed or lengthy of a discussion, although I'm sure Mr. Beatty would be happy to appear at the Finance Committee meeting, and you may want to call your own township assessors and ask them to appear as well, and they can assist in what their share of the process is.
Good. Moving on, under old business, We indicated discussion is in order on the landfill litigation. Mr. Boyd requested an opportunity to update the board as to status at this time.
Thank you, Mr. Chairman, members of the board. I met with Chairman Bosser recently so that he could be brought up to speed with regard to several matters, one of them being the landfill litigation. During our discussion, it appeared clear to me that it was again time to give you at least a status and update as to where we are. One of the items that I passed out before class this morning is a copy of the appellate court opinion that is currently the law of this case. You will recall when last I addressed you on this issue that the appellate court had ruled against us. This is their opinion when they ruled against us. We had previously requested, we lost at the appellate court, the matter went to the Supreme Court, but rather than file an actual appeal, it was recommended by outside counsel that we request the appellate court to be more specific in their findings of fact. They were also terribly terse in the manner in which they responded to us. You will note the unusual nature of this opinion in that it cites only one case as a basis for its decision, and that case is what is commonly referred to as Town and Country 1. It is cited solely, it appears to me and most attorneys, solely for the purpose of setting forth what the scrutiny will be on appeal, specifically the manifest weight of the evidence. They've used it for that purpose and that purpose only, and cited no other case law. Once this opinion came out, a decision had to be made whether to appeal this to the Illinois Supreme Court, let it lie and the case is over, or take some alternative action. Because of the timing of the opinion and the timing of the county board meetings, the outside counsel requested an extension of time for leave to appeal to the Supreme Court. That extension has been extended one additional time to January 23rd of next year. That gave sufficient time for me to address the board here in December and for you to mull this over between now and the January meeting with regard to what actions you want to take. Have your own private discussions with each other, with department heads, with the constituents in your districts, or with anyone else that you think is appropriate. Currently, the case is still under the jurisdiction of the appellate court because Waste Management has filed a petition for rehearing. And I know I'm now talking about several petitions. It's a little convoluted and complex, but they have filed a request for a rehearing. Under appellate court rules, they may or may not be entitled to that rehearing. That's going to be for the appellate court to determine. You're only allowed one rehearing per case, but it may be read that you're allowed only one rehearing per opinion. And since we've got a new opinion, Waste Management, I believe, I don't want to speak for their lawyers, Waste Management is of the belief that they now can ask for a rehearing on this opinion. The concern that our outside counsel has, and the concern that you should have if you wish to go forward at some point, is that the appellate court can rule at any time that the petition for rehearing is inappropriate, shouldn't be heard, at which point the 30 days to file the appeal would have already run. And any opportunity for anyone to take it to the Supreme Court would have passed, unless the extension was granted, at which point we're now looking again at January 23rd for that purpose. Where we're at right now on the rehearing is the appellate court can rehear it and say we stand by what we said, rehear it, ask for rebriefing, and make changes or alterations to its opinion, deny rehearing and make changes or alterations to its opinion, or conceivably, because one of the questions that is out there is whether the appellate court inappropriately addressed a matter that was not addressed by the Pollution Control Board, whether the appellate court may wish to send it back to the Illinois Pollution Control Board for a more detailed opinion or for rehearing of the limited scope of questions that were not directly answered. Suffice to say, if it goes back to the Pollution Control Board, it will go from there to the appellate court, from the appellate court perhaps the Supreme Court, it all depends. If it doesn't go back to the Pollution Control Board, it can remain at the appellate court level for quite some time, and then eventually go to the Supreme Court. When it gets to the Supreme Court, if it ever gets to the Supreme Court can affirm the opinion of the appellate court, which is the opinion you have here, reverse the opinion with direction to take further action, reverse the opinion outright and not give anyone opportunity, reverse the opinion and send it to the Pollution Control Board for further hearing. The odds are that they are not going to reverse the opinion and send it back to the circuit court or anything of that nature. However, it's the Supreme Court, they can do what they want. Keep in mind that when last you authorized action by outside counsel, you authorized the filing of the request for rehearing with the Illinois, or for return from the Illinois Supreme Court to the appellate court. That was successful in that the appellate court heard the case, ruled against us, again in a terse manner. We now will be faced at the January board meeting with whether to go forward. I believe the estimated cost the last time we were here and discussed it was $60,000 for the step that we just went through. I do not have a number for you this morning. I apologize. You are free to look at the money that's been spent so far. My rough estimate is we are clearly over the $2.25 million mark since litigation began. Whether we've crossed over $2.5 million, I really can't tell you, because I'm trying only to keep track of the money that's been spent since I've had to deal with outside counsel. But those numbers are out there, and you can take a look at that and attempt to meet with others and discuss the viability of how much more money will be spent. I will be addressing Mr. Helston and Ms. Lisher, Nancy Lisher, who is the appellate representative, to find out what sort of cost we're looking at based on the myriad of scenarios. I wish I could tell you it's clear cut. We're either going to the Supreme Court or we're not. Unfortunately, the nature of this case just doesn't seem to lend itself to simple solutions on appeal. So, that being said, are there any questions? No, good. Okay.
Mrs. Schmidt.
Thank you, Mr. Chairman. Jamie, so the Supreme Court will never rule on this themselves? They'll only send it back and forth, send it back to the appellate court, send it to the Pollution Control Board? They'll never rule on this themselves?
No, they may. The first opportunity they have, when we file a petition, let's be clear, when we file a petition for leave to appeal, we are asking the Supreme Court to hear the case. The first thing they can say is, nope, we're not hearing it. That's it. The case is done and over with. The second thing they can say is, yes, we will hear the case. If they agree to hear the case, then all of those options I told you about are available, or they can simply rule in our favor. We don't know, but it'll be a full-blown hearing if they agree to hear the case. Briefs will be filed, arguments will be heard. I presume the Supreme Court isn't going to waive oral arguments on this case. The parties will file initial briefs, responsive briefs, reply briefs, or arguments will be set and heard, and the court will take it under advisement. And the Supreme Court will issue an opinion, or they may issue a short order directing it again back to someone else. It'll be up to them. Keep in mind, our petition for leave to appeal can always be denied. And they can say, we're not hearing the case, we are sufficiently satisfied with the application of the law by the appellate court that we don't need to hear this case.
Right, and then we're done.
Then we're done.
Waste Management and Kankakee County appealed this together
No.
in this particular, it just,
This?
yeah. I mean, it wedges both together.
Well, that's,
Just, but
that's-
they both had their separate cases.
I would suggest that that is an indication of the appellate court's view of the county and the actions of the county in this case. The appellate court has coupled us with Waste Management because that's where the reading of the opinion suggests that's where they believe we belong, is paired to Waste Management's issues and interests.
Well, I think that's fundamentally unfair in itself.
Feel free to,
I'd like
Justice
to tell
McDane,
them
Holdridge, and
thing,
Schmidt,
too.
how
I'd like
you
to tell
feel?
them okay. But the Supreme Court did reverse the court's decision and told them,
No.
well, it says,
No, that's not true. What the Supreme Court did was direct it back to them for a more detailed, you will recall that the last opinion we received from the appellate court simply, in short order, said, Town and Country wins, county loses, and that's because everything went the way it's supposed to. And we requested that the Supreme Court direct the appellate court to give us an opinion that addressed each of the issues that were not addressed, instead of addressing the one issue that they felt was dispositive.
okay, because
And
this...
they did, and when they did, I guess the thing I would suggest to you that's indicative of the court's feeling on this, on at least 3 occasions, 4 occasions, the court simply said, and I'll cut it short, we were asked to determine certain things. We have, it was. We have, it was. We have, it was.
Right,
That's their way of telling us,
but it says
we don't
here-
like you anymore, and we don't want to see you here anymore.
Yeah, I understand. But this says, in their opinion, it says Waste Management won and the county has filed a petition for leave to appeal with our Supreme Court, which reversed this court and held that the decision of the board was not against the manifest weight of the evidence. So this says here that the Supreme Court,
I believe, I'm not going to know exactly where you're reading, but I'm guessing
on
they are
page 3 at the
referring,
bottom,
I believe they are referring to Town and Country 1.
okay,
Okay? They're not referring to this particular case.
the Town and Country 2.
Right. That entire paragraph is a setup for their citation of Town and Country Utilities, Inc. versus Pollution Control Board, 225 Illinois 2nd, 103, and then they put in parentheses, Town and Country 1. So that's their citation to the history of the parties' relationship and the history of appeals. They are citing, so that everyone is aware, to Town and Country 1, which they then go on throughout the rest of the opinion to use as their basis for ruling against the county.
Okay. Are we, we're still fighting 1, is that what we're doing?
No. No. This is Town and Country 2.
Okay.
1 is dead.
It's over.
It's a fair statement.
I hate to refer to it as dead. Yes.
Nothing there.
Town and Country 1 has, I don't think it's been autopsied by Mr. Gessner yet, but it's dead. All right.
Thank you.
Other questions, Mr. Enns?
Yeah, Mr. Boyd, if this does go to the Supreme Court, will the Supreme Court only rule on this narrow issue, or can the other issues be brought up?
You know, the Supreme Court's going to do whatever they want. You want to talk about a group of guys who really are not bound by anything other than procedurals, rules. If they want to rule on one issue, they'll rule on one issue. If they want to reopen the entire can of worms, they'll reopen the entire can of worms. It is certainly possible, and I think highly probable that there's going to be heated discussion amongst the justices of the Illinois Supreme Court about whether to take this case on appeal. They, I think, truly believed they had addressed the appropriate issues in Town and Country 1 and expected the appellate court to act appropriately based upon that. They were in some fashion not satisfied, I would guess, and I don't want to speak for the court, sent it back to the appellate court has said, okay, you wanted something more specific? Here you go. You wanted us to follow Town and Country 1? Here you go. We followed Town and Country 1. When it gets back to the Supreme Court, I'm sure there will be lengthy discussions about whether to have a hearing at all.
Mr. Whitten?
Thank you, Chairman. Mr. Boyd, in January meeting, will we have the opportunity to fire or rehire the outside counsel and continue fighting?
I would guess that that's exactly what you're going to want to do at the January hearing, January meeting, is make a decision about the future of this litigation. Whether you wish to continue on in the litigation in a limited fashion or an unlimited fashion, whether you wish to continue on with this group of outside counsel, whether you wish to have someone else pick up the ball and run. My guess is my thought was to bring this to you today for discussion so that come January, a reasoned and informed decision can be made by this board with regard to the future of this litigation.
Thank you.
Bernard?
Thank you, Mr. Chairman. I have a question on this. On page 8 at the top, where they're talking about the public safety, health, and welfare, are they actually ruling on Town and Country 2 here, saying that it's meeting the health, safety, and welfare? If you can clarify this?
I really don't want to clarify it, but I'll give you my personal opinion. I'll be honest with you. I don't want to clarify what an appellate court says because I got no idea sometimes why they do what they do.
Are they saying that it conforms to health and safety and welfare standards, or not?
What they, in reading it, for those of you who don't have a copy in the audience, I want to read you the paragraph. We are next asked to determine whether the board, meaning the Pollution Control Board, erred in finding that the proposed facility would protect the public's safety, health, and welfare. We review the decision of the board to determine whether that decision is supported by the manifest weight of the evidence. They then cite Town and Country 1. We have, it was. What they are saying there is they've been asked to decide whether the board, the Pollution Control Board, was wrong in finding that the landfill would protect the safety, health, and welfare of the public. They're saying that the finding of the board was that the landfill would protect the safety, health, and welfare, that finding is not against the manifest weight of the evidence, which was the standard set forth in Town and Country 1. They are not determining whether the safety, health, and welfare has been protected. They are finding that the determination by the Pollution Control Board that the safety, health, and welfare are protected is not against the manifest weight of the evidence. In other words, they're saying we were asked to find out, did the Pollution Control Board do its job correctly? And our response is, yes, they did.
So, does this mean then that...
Mrs. Bernard, could I interrupt? We need to change the...
Okay. I can wait.
I'm sorry.